Hi, good afternoon. If you're here today, you're here for our Should I Pay Temporary Disability webinar. My name is Greg Lois. Standing to my right, your left is Tashia Razul, and to her right, your far left, Rachel Aronoff. Tashia is one of my partners here in the New York Workers' Compensation practice, and Rachel is one of our trial attorneys. We're here today to help you answer questions that you get from your location, your insureds, and those locations are asking you things like, do we have to pay temp? How much do we have to pay temp? And how can we stop paying temporary disability? That's what we're going to hopefully have all of our attendees be able to answer when you leave this webinar today. This is part of our overall New York Workers' Compensation webinar series. It's always the third Monday of the month. There are now 2 sessions, one at noon, one at 3 o'clock. And if you're ever wondering what the new topics are going to be, they are absolutely on the events page of our website. This is just a small part of the overall sort of educational outreach that we do. We also do handbooks. There are literally thousands of articles on our LOIS LLC's website going back for 10 years. We do a monthly newsletter in which we summarize all of the articles we write every month, and we're averaging 10 to 15 new articles on New York and New Jersey workers' comp. And, of course, we do these monthly webinars that we invite everyone to attend. Today we're going to talk about indemnity benefits, temporary total disability, temporary partial disability. We're going to talk about how we end those benefits as well, because that's typically what we're doing as your defense attorneys. Totally live. So if we mess up today, please understand this is when we expect it. Right, that's going to happen. It's happened. Feel free to please ask us questions as we go. We've discovered that as we get to the end of the webinar, hey, where are all the questions? And people don't start typing in their question until the thing is like almost over and that last screen comes up with questions. Please start asking questions right in the beginning as we go along. We can see them. I've got a computer right here popping them up. Also, from your control panel at your computer, you should also be able to access our handouts. And there are 2 handouts. There's the one that we email to everybody, which is just the general handout. And there's also one just on EDI, because some of our attendees are dealing with EDI and want to know sort of those rules. We have a very lengthy 13-page sort of summary of the EDI requirements. And that is in the handouts. You can download them now. Okay, without further ado, let's talk about workers' comp benefits. Rachel, take us away.
Well, there are 4 types of benefits. So we have medical benefits, we have temporary disability benefits, we have permanent benefits, which are subdivided under loss of wage earning capacity and schedule loss of use And there's also the death benefits. So these are the 4 types of benefits that we have. Okay. And today we're only talking about the temporary disability benefits, and the permanent disability benefits will be covered sometime later on, I believe in November of this year.
Yep, so that's going to be its own topic. That's a big enough topic to really take up its own day. So we are talking about money benefits today, but it's only going to be temporary disability benefits. All right, let's talk about them. When do we pay them?
Okay, so they're payable only in compensable claims. So if the claim is being accepted by the carrier or formally established by the board, that's what we call a compensable claim. Even though the claim is compensable, though, if there's 7 or less days of lost time, the claimant's not entitled to benefits for this period. In other words, there's a waiting period. So in order for the claimant to receive benefits for this first 7 days after the injury, after the lost time, there must be 14 days total of lost time. So on the 15th day, that's when the benefits would be issued to the claimant, and he or she would actually receive benefits for those first 7 days.
And do they have to be sequential, like all in a row?
Absolutely not. So it can be 3 days this week. He can return to work, and then it can be another 3 days as long as it adds up to 14 days. That's what will trigger him or her receiving benefits. Okay. And so if the claim is not compensable, obviously the claimant is not entitled to temporary disability benefits. So we do want to point out something with the denied cases, though, in order to prevent the carriers from being on the hook for temporary benefits to the claimant. So there's this thing called the 1810 rule that's being thrown about. It's our lingo. And what it means is that if the carrier is going to deny a claim, it must be done within 18 days of lost time, so before or on the 18th day that the claimant started losing time, or it has to be done within 10 days of the carrier becoming knowledgeable of the lost time or the injury.
All right, and this came from the payer compliance memo, and has really been a big problem for us because under the statute, we have 30 days to deny a case.
Right.
But the board is saying, no, if you're looking into a case, you're investigating, you don't even have medical records from the claimant, we're going to ask you to start paying temporary disability benefits at that minimum rate, which I think you're going to talk about in a second, until you sort of make that determination or until medical gets submitted to the board.
Wow.
All right. Let's talk a little bit about temporary disability benefits just in general. Can you talk us through how it's calculated and what it's based on?
Sure. The general, understanding is that you have a 52-week year, and what your general earnings are during that year are then divided by that 52-week period, and then you take 2/3 of that amount, which is used to account for tax purposes, and that becomes your average weekly wage.
Mm-hmm.
And then after that, that becomes a temporary disability benefit, the 2/3 of that, which is 100%, and then you also have the minimums and the maximums that are statutorily regulated.
All right, let's go through the step by step. So you're talking about average weekly wage as being sort of the foundation or the cornerstone of how we calculate that compensation benefit.
Yes, absolutely. That's the most important part because all of your future benefits in this claim, in the life of that claim, will be based on the average weekly wage. So all the calculations stemming from that will be based on that. So it's important to know that the board will use various ways to calculate it. They'll either use a 200 multiple or a 260 multiple in order to get that average weekly wage. And basically what that means is the actual number of days worked by that claimant. So the closer we get to 260 days of a work year, basically, the more accurate the average weekly wage will be reflected. For some employees who work less than that, the board will still try to even things out and use the 260 multiple. However, we try, in our practice, we tell, use the straight division method, which is, the actual earnings divided by 52 weeks. So then we use the actual earnings of the employee.
We should always be calculating it using straight division.
Right, we try to.
Yes.
Sure.
Yes. Doesn't always work out.
Yeah, we'll wait until the claimant or the claimant's attorney make their arguments about the multiple, but we're never offering up a calculation using the multiple because it almost always makes the average weekly wage higher, which of course will influence the amount that you're paying out for temporary disability benefits. So straight division is the way to go. That's what we walk in the court with, saying this is what it should be. And we're usually successful with that. Once in a while we get we have to end up doing it using the multiple, but straight division is what we recommend.
Okay.
We also have to watch out for seasonal employees and part-time employees because their wages won't be calculated at the same rate. So we'll try to use their actual wages, which is, as close to however many months or weeks they worked. For full-time employees, however, we have to use similar workers if the claimant worked for less than 52 weeks. In that case, that gets a little dicey at times because, who's a similar worker? And we'd like to say that these are people who generally work in the same industry, in the same position, and most importantly, in the same geographical location, because as we know, wages vary based on state to state. Even within the state, New York City wages versus upstate New York wages will be different.
Right.
Sure.
And it's also good to note that even when there's not 52 weeks of wages for the actual claimant, the judges would direct the carrier to produce the wages for the time actually worked. And they usually do this to compare it to the calculation that's being made because, as you mentioned, using the 260 multiple, if we were to do that for a similar worker, it might be significantally higher than what the claimant actually worked for the 6 months that he worked, right?
We're typically fighting that.
Yes.
Yeah. Okay. I'm going to take the easiest slide that there is, which is rates. The rates change every July 1st. They've gone up every year since they changed the statute in 2007. The current rate is $864.32. If you're wondering where does this rate come from, it's based on the state average weekly wage. It's calculated. It's on the board's website. It seems like this nowadays, 5 or 6 years ago, they were announcing the average what the new max rate was going to be, 3 or 4 months before July. Now I think they just announced it a couple of weeks before.
Mm-hmm.
But we, that's the new rate. The minimum rate is still $150 a week.
Mm-hmm. And also a reminder, the minimum rate is based on the actual date of loss.
Correct.
So there's no
good
increase
point.
as the case goes along.
Good.
Right.
Yes. Should have said that. I thought I had the easiest slide. All right. Who wants to talk about the terms of art?
I can take it.
Okay.
We have total disability, which is, 100%. Doctor says you're completely, totally disabled, temporarily, but totally disabled. And then under that, we have mild, moderate, and marked, which is 25% for mild, 50% for moderate, and 75% for marked. At times, we go and you hear terms like moderate to marked or mild to moderate, which is basically, the shorthand way of saying the difference between the two numbers.
Right. And those are usually, so we generally see the doctors using just the mild, moderate, marked, or total.
Mm-hmm.
But the in-betweens are sometimes, once in a while, you'll see a doctor saying a 66.6 degree disability, or when the parties are compromising, or sometimes even after the cases are litigated, the law judges would find something in between, right? But why is this important? Is because the percentage of disability, the degree of disability, that translates into the amount of money that the claimant will receive as temporary disability benefits, right? So the medicals do control the amount of money that the claimant will receive.
Okay, and before we go any further, and when we're talking about calculating those benefits, I just want to remind everyone, if you have questions, please be typing them in now. We are a little bit more than halfway through our slides, so now's the time to be starting to think about your questions. Let's talk about calculating the benefit, and just, I guess, another thing to talk about is this is a New York-specific thing. The word mild and moderate and marked, they're not found anywhere in the statute. They're not found in the regulations. These are just sort of terms of art that have developed over many years, and they're sort of rules of thumb. But there's absolutely nowhere you're going to find in the statute that says a marked is worth 75% disability. That's just something that's grown up over time. This is how I calculate benefits when I'm doing it, just how it always comes out to the right number, average weekly wage times whatever the percentage of disability divided by 150. And you always work out the exact right rate. That's my quick way of doing it. Underneath it, we put or some other sort of methods. All right, let's talk about what we really care about. Okay, so we've done all the table setting.
Cutting them off.
Cutting them off. All right, Tashia, take us away.
Question.
Yes.
Yes.
Right.
Okay, so the goal should always be to cut off those temporary disability benefits, right?
Yes.
And how can we do that?
Yes.
Force them back to work. Get back to work. Your injury has healed. It's resolved. It's time to go back. Stop collecting, right?
Yeah, I think we've all done this enough that we're getting kind of jaded. And we've lost all semblance of sympathy for, the person who's been home for 3 years with a back sprain. And it's just, non-operated, just annoys us. And so let's talk about how we get them back to work. What do we do?
Okay, so we can push them towards MMI and then permanency, but that's something we'll talk about in a different webinar.
Right.
But with respect to cutting off the temporary total disability benefits, raise labor market attachment, challenge their attachment to the labor market. Now, in order for us to do this, though, we need medical evidence. As I mentioned earlier, degree of disability, it's controlled by medical evidence. The claimant remaining out of work, it's controlled by medical evidence.
And they're picking their own doctors.
Absolutely, and the doctors know what exactly to write in the reports to keep them out of work, right? And the claimants also know what to tell the doctors so the doctors can keep them out of work. What do? Get an IME. We always have to challenge the medical records that the claimants are producing. Now, in order to challenge their attachment to labor market, there must be a less than total disability.
Right.
Right? So
anything less.
Anything less.
So 99 and below.
Yes, 99 and below. We are in there challenging labor market attachment. And so once in a while, you'll get a claimant's doctor finding the claimant a less than total disability. If that's the case, that's sufficient to raise labor market attachment.
Right.
In many other cases, though, they're going on for a couple of years and their doctor is still finding them at a total disability. Yep. So what do? Get the IME. Hopefully the IME is going to find a zero disability or even anything less. Anything less. And we'll have to litigate the issue if that's the case. So just to be clear, in order for us to be able to raise labor market attachment, the claimant's own doctor must be placing him or her at a less than total disability, or there must be a finding by the law judge, which is after depositions, that the claimant has a less than total disability. But we do know, though, if their doctor is still placing them at a total and we have an IME finding less than total disability, start the process of raising labor market attachment,
and
right?
I think we're almost skipping over the easiest one, which is, well, the easiest one is their doctor says you're at maximum medical improvement. Great. Temp stops.
Right.
Okay.
That's true. Mm-hmm.
The second one is, well, their own doctor puts them at something less than total, and we can offer light duty.
Yes.
I mean, this is the number one thing that
Absolutely.
employers can really do to help themselves. Have
Mhm.
some kind of light duty available. I mean, sometimes it's just not available. A warehouse distribution center or something, you got to do a truck driving job, and you can't do that partially disabled. I get that. But if we can offer a light duty position, yeah.
You just have to be mindful of the restrictions that are being placed.
Right.
A light duty, for one may not be the same as for another, depending on their restrictions.
So
Yeah.
we'll have to see what the doctors are saying about the restrictions.
Exactly. And so we're kind of skipping over that whole topic of offering that light duty job. It's very well covered, I think, in the handout with even model template letters to send to the claimant to say, come on back, I got something that worked for you. Okay, so then the other times we can cut it off is they admit they're retired. Right? They come back and go, hey, you can come back to work. And they go, no, I retired. I'm done. I'm out. And I think what we're going to talk about is the defense that we can actually make, which is the attachment defense.
Right.
Okay.
But, once in a while, the claimant decides to go back to work and
Yeah, surprise me. Yeah.
so,
I don't know.
that's
Very
rare, right?
Yeah, that's the unicorn.
If only
you know what
that
I mean?
would
That's-
happen more often.
I think it really just applies for people who are making a significant amount of money.
Sure.
It's
Right.
more beneficial for them to return to work rather than, stay home.
Right, and you get
Yes.
that gets to the politics of the compensation rate. If you make less than about $50,000 a year, you're better sitting home collecting workers' comp because your marginal tax rate is going to be higher than 33%.
Yeah.
And so you get to this place where not a lot of doctors and lawyers and college professors and high-income earners that are sort of sitting home collecting comp. It's not
Right.
worth it to them. So that's an excellent point, Rachel. All right, let's talk about our steps for challenging attachment.
Okay, so first the carrier should start sending out the C-258 forms as soon as there is a light duty
Which we've all
release.
seen, right? Everyone has
Yes.
seen these things. These are not an official form, meaning that it's not required, but they do have a model one on the board website.
Right.
So,
Mm-hmm.
we like to tell clients, like, hey, this isn't like a specific thing, like a pH 16.2. You have to use it. You can really use any form you want, but that's a model one.
It's a guide, and it has all of the information that they should be providing to the carrier to show that they're actually looking for a job and they're remaining attached to the labor market. So after the carrier sends these out, we usually recommend that they're sent out about every 2 weeks or so. You want to be aggressive every week.
Sure.
But guess what happens? They never return them. Never return them.
Because again, they're
ahead
not
of time.
required. It's not a board-required form.
Exactly. So what do we do next? We'll just have to file an RFA-2 to get things going. The RFA-2 is going to raise labor market attachment. The board's going to schedule the matter for a hearing. We walk in there. We tell the judge why we're raising labor market attachment and request that the claimant be directed to provide proofs of job search and also the opportunity to cross-examine him or her. And we do note, so when the hearing is on that very first time for labor market attachment, that's when the claimant usually shows up with like sheets and sheets of paper for the
Right,
job.
that they created on the drive to the
Right.
courthouse.
Sometimes on napkins.
Right, napkins. Yep.
Yes.
Exactly.
So at that very first hearing, you want to collect all of that information, and you can actually subpoena those employers to see if the claimants even applied for those jobs, right?
And some of our clients are using vendors that are doing it with letters.
Yes.
Same thing.
Mm-hmm. And we'll have sufficient time between the first hearing and when we have to come back for the claimant's testimony so we get the subpoenaed results back. And in many times, we've done this so many times here at the
No record of application.
Nothing. So we'll use it against them at the hearing where we're doing the cross-examination. And we're usually pretty successful with finding that, getting a finding that the claimant's not attached to the labor market.
Yeah, and in my, see, we're subpoenaing them, so they see those subpoenas going out. We have to copy our adversaries by law, and all of a sudden they realize I turned in this sheet with, it says always says CVS, Rite Aid, Home Depot, whatever's on the neighborhood on the way
Those
to
are
the
the
courthouse.
classics, yes.
And they turn in the sheet, and then they see subpoenas going out, or they use a vendor, and the vendor's sending out the letters, and all of a sudden it's an attack of the truths.
Right.
And I think it's important just to mention this. Attachment is never going to win the case. It will just terminate benefits for a short period of time. And this is very tactical. We're doing this to set up the case for Section 32 lump sum dismissal, which is, when I fall asleep at night in my bed, I think about Section 32s. When I wake up, I think about Section 32s. So that's really, we're just trying to push a pain point. We're really trying to make them uncomfortable so we can get this case set up for a lump sum dismissal.
Right.
Because they're sitting home fat, happy, watching Judge Judy, drinking beer in their underwear all along. We're just trying to interrupt that, make them come to court, make something happen so we can get a 30.
And we've actually seen some of that because after that first hearing, when the matter is set for labor market attachment, we usually get demands from the adversaries, right?
Absolutely.
Because the claimant knows that he doesn't want to look for work. He's enjoying staying at home.
The gig is up. The gig is up. They got it to me. Yeah.
So now he better work in collecting a lump sum money and then just figure out what he's going to do after that.
So one other thing to note, I think importantly, the places that these claimants are claiming to be looking for work actually have to be hiring somebody.
Sure.
Yes, important.
You know, many times we'll get, oh yes, we went to, so-and-so and so-and-so to look for work, and you ask them, were they looking? Did they have a help wanted ad out? No.
Right.
Well, then how does that count toward actually looking for a job that wasn't hiring?
It's not a job if they're not hiring.
Exactly.
And you also mentioned that in some of you go to Manans and you go to Binghamton.
I've covered upstate,
Yeah, and you've told us that up there, the judges are saying basically if they're not terminated.
Well, yeah. So there have been some recent, board panel decisions from 2015. They haven't caught on everywhere. Hasn't, just beginning to get some traction in some jurisdictions. And basically what they're saying is if the claimant is still employed, hasn't been officially terminated from their employer, then they're considered to be attached to the labor market. So in that case, there's no requirement that they go out looking for new jobs because they're technically still employed by their employer.
Right.
So
and
that whole argument, of labor market attachment comes into question then.
Right.
Well, are they or aren't they?
Because they might just be 50% disabled and can go back to that job that they have at the employer.
Right.
So that doesn't make them attached to the labor market.
Right.
We should
Exactly.
still challenge that,
Absolutely.
right?
Absolutely.
They have to be looking for jobs within their restrictions. The employer may not have jobs within their restrictions,
That's
so they have to go out and find those jobs in order to remain attached to the labor market.
Yeah.
And the carriers should continuously make these arguments because, like Rachel said, they're board panel decisions. American Axle still controls. They have to meet all of these requirements,
Yes.
and we still should be challenging that,
Absolutely.
even though some of the judges are trying to use it as an escape, right?
Yeah, absolutely. All right. So let's talk about one other thing. We definitely have seen claimants that go to the state vocational services. Some of our clients have used private services. We're familiar with CBI or Catalyst, which will find a job. Can we talk about that a little bit?
Yeah, absolutely. I mean, there are places available for many claimants, some through the state, some through private agencies. Many, don't want to go through the private agencies. They just kind of go to the state. They show up for the interview. They fill out some paperwork, and they put little check marks and some things or other, watch, an hour video, and then they go home.
This is the Workforce One sort of shenanigan that we've observed.
And then they put that on their, C5, 2588 form, and they say, okay, we've looked for work, and nobody ever called me. They didn't follow up. They didn't show any efforts to reach back out, and that's pretty much it. And they think that's sufficient. Then there are other places that are, I think, a little bit more yield better results, which are the private agencies like CBI, like Catalyst. Thank you. Forgot the name for a moment. That actually, it's like a work placement agency. They go out, they find you jobs that you can do within your restrictions, some from home, some from, locations specific to, your location, which, by the way, should be important to know that it should be within the geographical location of the claimant.
Oh, right.
Yes.
You had the case where the person lived in Georgia and they were finding them jobs in Florida.
Yes,
That's not
yes.
gonna
That, going across state lines for a job may not necessarily work in many places.
Well, the Catalyst, that's something anybody could do. It's a telemarketing job, basically. They even send you the phone, I think.
Yeah, you don't have to do anything. You sit home, they send you a headset, they send you a list, you log into the computer, and you click a button and it dials for you. You don't have to do anything, really.
Yeah.
Just speak.
Anyone can do that job. Come on.
We would expect them to. And one other little comment, the claimant does have to go to Workforce One. They have to register. If they have to go and register a resume, they've got to do all these things. We've actually subpoenaed Workforce One, this office,
Yes.
on this, to see if the people are actually showing up and, discover, hey, they're checking in, but they're not really doing any of the follow-up.
Right.
So that's just a thought. All right, those are sort of all of our prepared remarks. It's time for questions. Now, I'm going to go over to the computer. I hope there are some questions. If not, please type as fast as you possibly can. Give me 1 sec to come over
Typing
here.
skills are coming into use now.
All right. Okay, so Janet, asks a question. If the carrier does not receive a medical report to substantiate for lost time, do we have to pay the claimant within the 30 days from the receipt of the claim? Are we in a penalty situation if we do not pay within 30 days because we do not have evidence of lost time? Thanks. That's from Janet. Well, let's answer that exactly, because I think this is a question that's absolutely about the payer compliance.
Exactly.
And this is the problem that payer compliance creates for our clients, which is under the payer compliance rules, if you have notice of an injury, you're supposed to just start paying TIP. You don't know if they're actually temporarily totally disabled or not.
Right.
So the guidance from the board has been just start issuing the $150 a week, which is the state minimum. So that's what the board is telling us. Now, the threats from the board have been that if you fail to do it, there's a $50 penalty, and then there's a $1,000 penalty, which is, not nothing. So, yeah, there is actually a penalty situation. But the challenge is, and I think what Janet is alluding to here, is the idea of what if they never produce medical? Right? So they've never substantiated it. You're not going to get a penalty if they've never been able to substantiate it. They just started missing time from work. Again, this puts employers in a terrible situation where somebody's missing from work. We don't know why exactly, or they claim they were injured at work, but they're not. There's no medical. We can't get any medical, and now we're supposed to just start paying them. So this is one of the challenges in this jurisdiction. Let's see if we have any other questions.
And, the carrier could file an RFA, too, at that point if, a long time's going by and the claimant's not submitting medicals, right?
Well, I love that idea, except for how long does it take the board to list
That's
an
true,
RFA?
a couple months,
I mean, the answer is, it's all over the place. It's spotty. And it doesn't even seem to me, our practice is half the state. It's basically Albany on south. We're going to 15 hearing points. And it doesn't seem to be like Brooklyn is slower than Albany or it's just slow and unpredictable everywhere.
Yes.
The only thing we've discovered is with RFAs, and particularly when we're trying to get a Section 32 settlement put on the record, is just to call the board every day, have a paralegal pick up the phone and say, when are you listening? When are you listening? When are you listening? In fact, one of our clients, Andy, he calls him like every single day to get his Section 32s listed because it is very unpredictable. So it's not, we want to give practical advice. We want to tell people, hey, this is the truth about how it's actually working in this state. But it is a frustrating jurisdiction because there doesn't seem to be a lot of predictability as to when those RFAs will actually get listed. All right, either we did a great job or this isn't an exciting topic. That's the only question we got today. All right, so if you have any more questions, please, Tashia to my right, Rachel to my far right, you're far left. Their contact information is on the screen. Please feel free to send them any emails, any questions. If they just didn't come through because of a computer glitch, please send them to us via email. Next month, our topic is the New York Medical Treatment Guidelines. We're going to be talking with Declan Gourley and Janet from this office, and we're going to be presenting some ideas about how to, reduce medical costs using the medical treatment guidelines. Let me just make sure this is up on the screen because now I realize I didn't share the screen. And with that, we're out. Thank you, everybody, for participating today. Have a great day.